I'm Regan. I'm the Executive Director and one of the staff attorneys at the Civil Liberties Defense Center. Our website is cldc.org. We have a lot of resources and training materials on this topic and many other topics related to activism. And with me is Cora Borradaile. She's an Oregon State University computer science professor, cryptologist, and tech genius. And so I'm thrilled to have her join me on this panel. This is actually the first time that we've ever given this presentation or this talk. So I'm going to apologize in advance for not being a super PowerPoint guru. And we're going to do a little switching back and forth of computer screens because we are not slick as we usually like to be. So, other thing I want you to know is there are several people recording this panel today, both audio and video. We're going to ask that any video be focused on the two of us and not at the crowd. As a surveillance panel, we obviously assume that there are both overt and not so overt recordings being made today. So if you do have questions at the end, please make sure to not make them personal or fact specific because it is being recorded, including a couple of different radio programs. So just be aware of that. So we're going to try to get through some content and then open it up for questions and discussion. We sort of planned this to go over some basics. There's so much that we could possibly cover on this topic that we could probably have our own conference on this topic. So we just thought we'd lay out some basics and what we thought maybe a lot of people might be thinking about or focusing on right now in their organizing or activism, and then let you kind of direct any other topics that are kind of on the forefront of your minds or anxiety. So we like to start off any kind of digital security or surveillance talks by talking about this quote from one of my former board members. Awareness is 2 steps ahead, paranoia is 2 steps backward. By that we mean, being aware and trying to use best practices in your organizing and activism is responsible, is professional, we like that. But there really is no such thing as 100% security, 100% trustworthiness, et cetera, et cetera. And so, if you are trying to constantly know what is the latest threat that could end you in jail, you're going to spend a lot of time and it's going to change from day to day. What we tell you today could be not true in a week or a month. So this is one of those topics that you really do need to reasonably stay up to speed. If you're not already on CLDC's newsletter, we do send out a newsletter about once a week to once a month with updates on both digital security and other surveillance spying issues that are coming up that we become aware of. So I wanted to kind of start off with some basic definitions. My colleague at the CLDC did a panel yesterday on security culture. That's not the topic for today, but it is definitely the start of how do you protect yourself from surveillance of any kind, whether it's corporate or government. And security culture is just basically a set of norms that you and your community sort of agree on based on the risks and threats that you feel are warranted or prudent. The idea is that by using security culture, you're not only keeping yourself safer, but you're keeping your fellow activists and organizers safe as well. Don't ask, don't tell is actually a good motto for security culture, and by that what we mean is if you are in a meeting and you tell your 5 other folks at the meeting that you're planning to do something illegal, you've just potentially incriminated your friends in that act by simply disclosing it to them. There are crimes like conspiracy and aiding and abetting and racketeering where I don't actually have to, you know, drive the getaway car or be involved in the bank robbery to get arrested or charged with it. You know, just you telling me about it and me not going to the cops and snitching you out can get me in trouble. And so you don't want to place other people in risk like that. And so, you know, don't be offering information that that people don't need. Now, where this gets a little more difficult, how many people have ever been to like an action camp or a mass action like Shall Know or Break Free or any of those kind of larger events? If you've been to those, you know that, you know, organizing is kind of done front and center out in the open, and very often in those models you'll hear people say, you know, there's 3 different levels of risk that we're going to be taking. There's the red group, the yellow group, and the green group. You know, green group are going to be those people who really don't want to get arrested and are going to, you know, stay in a safer zone. Red group means you are there to get arrested. You know, it's more likely than not that you're going to get arrested. And then yellow group are those people willing to go to jail, but they'd like to avoid it if possible. You know, when that type of organizing is being done, you know, if red group is sitting there like, we're gonna go do X, Y, Z in front of all of us, we've all just been made a part of red group's action. And so you really need to kind of think about what you're saying out loud in front of other people. Did they consent to being part of your conspiracy or not? And if not, find a different way to organize and communicate what's going on. Don't forget that you can always back away from an action. You can always say no if you get a bad feeling, if you decide today's not the day to go to jail, you know, if something comes up that gives you the willies, you're better safe than sorry. We're going to talk more about snitching and getting other people in trouble. And then we also, you know, want to make sure that people are really careful about what they say in public, especially what they print. And this will include, you know, Facecrack and Instagram and all sorts of social media as well. And we'll get into that in a lot more detail. When you're talking about organizing and meetings, you know, it's important to know what you're talking about at that particular meeting. If you're talking about your bake sale, you probably don't care who's there and who's listening. If you're talking about something more confidential, where something might need more security, you know, not only do you need to think about what is the content of the meeting, but you want to think about the location, you know, how easy would it be for outsiders to be able to come in and record that meeting, access the meeting, et cetera, et cetera. Using things like vouching to make sure that the people that you are meeting with are who they say they are. And you want to be careful of things like your phones and computers and other things. You don't want to leave those things on a table in a public space where other people could potentially access them easily. So we want to also just talk about, you know, bragging, gossip. Those are fairly obvious security culture violations when you are organizing. Bragging about your past, you know, heroics, or bragging about something you're going to do in the future. If there is someone there that is gathering intelligence, you know, it's when we talk about security culture, we're not just talking about what's going to land you in jail. We're also talking about giving the enemy intelligence that they can use to develop plans about where our weaknesses are, you know, who our weaknesses are, how we organize, how we come up with campaign plans, how we pick targets. You know, all of that stuff is just as juicy and interesting to corporations and the government as trying to figure out whether, you know, someone is going to break the law and get arrested. In fact, you know, the acquisition of sources, you know, finding someone who is vulnerable for some reason, you know, maybe they're in a lot of debt, maybe they have a mental health issue, maybe they have a drug addiction, you know, some vulnerability, you know, the government and corporations, but more often the government is looking in your community for, you know, who could we pluck out and use against that community when the time is right or if the time becomes right. So, you know, that saying, you're only as strong as your weakest link, you know, that really does ring true with regard to organizing, especially if you are doing, you know, higher risk organizing. Which, just to say it, you know, I think anything dealing with climate at this point, like oil, gas, coal, you know, infrastructure, what we call critical energy infrastructure campaigns, I would put all of those in the high risk category at this point, just because of the level of corporate and government intelligence and anxiety that they are having about the great work you're all doing. So just to define a few different things, infiltrators are somebody, whether it's a corporation or an FBI agent or a cop, that is entering into your group and pretending like that person is one of you. You know, they are attending the meetings, they're attending actions, they're smoking pot, they're dating you, they're breaking the law, you know, and all the while they are either reporting back or they are there to incite, escalate things, provoke, you know, things that maybe none of you had any intention in being a part of. An informant can either be someone within your community or someone from the outside that comes in, and their job is to lay low and relay information back, either to the corporation or to the government. So they're sending emails saying, went to the meeting last night, here's who was there, here's what they talked about, this is where the action's gonna be, you know, this is what they're gonna do. The idea being, you know, that information will allow the state to circumvent your plans. And for the purpose of this presentation, if I say the state, I am actually, if I'm using that term, I'm talking about both government and corporate entities that are very often, you know, one and the same anyway. A provocateur is somebody who is employed by the state and is basically there to escalate violence or to increase everyone's risk. You know, this is the raging grannies are holding a banner and somebody shows up with a Molotov cocktail. You know, like that is the classic example of like a provocateur. Someone from the outside with bad intentions who is there to basically turn your work into something that it was never intended to be in order to get you into a lot more trouble. And we'll use, you know, Standing Rock and Tiger Swan as a pretty clear example of that down the road a little bit. And then a snitch is just a snitch, you know, that is just the slang euphemism for all of the above, basically. Somebody who turns their back on their community, oftentimes to get themselves out of trouble. You know, they are, you know, they get in trouble and they just basically decide so that they don't have to go to jail, they're going to get other people in trouble. And the CLDC and, you know, several other organizations, and we have a pretty strict rule. We will never defend cooperating witnesses or snitches. We believe that if you are engaging in activism, the state is your enemy. You know, we are fighting against the state, and you've chosen a team. You're either on our team or you're on their team. And if you become a snitch, you've chosen their team, and you're not welcome on our team. That's just kind of our general philosophy, and we hope many other people share that. Because the bottom line is, once an informant, always an informant. People don't get to change stripes like that. And if you're willing to basically lie or give up the faith that other people have given, you know, for whatever the reason, you know, you're not deserving to, you know, you can't work with those people, basically. They've proven themselves to be liars and put their own interests ahead of others, and that's probably going to continue anytime the rubber hits the road. So there's a term called threat modeling. This is used in a bunch of different contexts, but what we might mean by it is, you know, security culture and measuring surveillance threats and things like that. It's not a one-size-fits-all situation. You know, at different times with different people under different situations, the threats and whatnot are going to be different. So when we use the word threat modeling, it just means you are assessing your own campaign or your own individual risks. And then you are, really kind of taking some thoughtful time in thinking about all of this stuff, and then also thinking about what measures you can take to at least better protect yourself. Like I said, you're never gonna have 100% protection. We can strive for that, but it's pretty unrealistic. But it is actually important, as you are trying to save the planet, to take some time to make sure that you can be in this for the long haul, and that your campaign is going to get to the finish line and be successful in what it's trying to do without being circumvented or imploded or destroyed. And so these are just some terms, some very serious sounding terms that we use when we're talking about threat modeling. An asset is just something of value, your membership database, your strategic 5-year campaign plan, your volunteer list, that can be an asset. A threat is basically anything that could damage or compromise that, like being hacked, for instance, or having somebody come in and steal the computers from your office, that can be a threat. A vulnerability is some kind of weakness in that system. Maybe you're not encrypting your computers. Maybe your bookkeeper is a person with a serious drug addiction who is stealing from you. All of those things can be vulnerabilities. An attack, also called an exploit, are actions taken to actually harm that asset. And then a countermeasure is basically what you attempt to do to mitigate some of that risk. A couple other definitions. So a warrant, I'm sure most of you have heard of, a warrant. A warrant is something that the cops show up at your house with so that they can search your house and take stuff out of your house. If you are present when a cop delivers a warrant is something that has to come from the state, corporation, meaning cops, or FBI, or a government agency. A warrant is a piece of paper signed by a judge that gives the state, the cops, permission to basically break down your door, enter your home without your permission. You don't even have to be there. They're going to be allowed to search and seize things based on that piece of paper. It's going to have name, address, time periods, what they can take, where they can look. If you're home, you can look at the warrant and inspect it. If you're not home, they normally leave it stapled to your front door or something like that. A warrant can also be a telephonic warrant, so cops show up at your house and it says, they can search your house, but it doesn't say your car, and you look out the window and they're rifling through your glove box, and you're like, oh, officer, this warrant does not say car on it. They can get on the phone to a judge and say, hey, judge, we forgot car, will you add car? Judge says, no problem, added, and now you just turned what would have been an illegal search into a legal search via a telephonic warrant. So in that circumstance, you're supposed to lay low, not point out their errors, and if it ends up being a prosecution, if it ends up being a court case, your lawyer can basically file a motion that can get all of that evidence thrown out. It's called a motion to suppress. And if it's granted, that means all of those ill-gotten goods get tossed out, and very often the charges that accompany it as well. Even if cops show up with a warrant, you should always say, I don't consent to this search. You can say, I'm not going to resist you, but I don't consent to this search. By saying those words, if it turns out that anything the cops are doing was improper or illegal, you've just given your lawyer a way to fight that. But if you say, well, I guess you're going to come in and, I got a dentist appointment in an hour, so go ahead, you've given up any right to fight about that. If it turns out that that search was illegal, you've just made it legal by consenting to it. So you always want to say, I'm not going to resist you, but I don't consent to this search. Say it over, say it often, and then zip your lips and assert your Fifth Amendment rights and remain silent. There are a lot of exceptions to the warrant requirement. So oftentimes you're not gonna see that piece of paper. You know, you're gonna get pulled over in your car and they're gonna bring out the drug sniffing dogs. Or, you know, you're on your way to a protest and you're in a U-Haul truck and all of a sudden the cops are crawling around the back of the U-Haul truck or something like that. And that's because there are a lot of exceptions to the search warrant requirement. Too many to talk about, and they're constantly changing. So again, no matter what the circumstance, you always just want to say, I don't consent to the search. Just to say, the most common for activists are the automobile exception, going to the action, leaving the action, far more common than going to it, because you're obviously easier to track and target as you leave. And side note, you know, exit plans from actions are actually more important than figuring out the chance and what's going to happen during the action to keep people safe. Plain view. You know, if you've got your sleeping dragons in the back of your Subaru and everyone can see them as you drive up to the Capitol, that is plain view. And if a cop can see something that they believe is illegal in plain view, then they're going to be able to search it, seize it, sniff around it. Those are the most common. The cop has to be lawfully present at the place where the evidence can be plainly viewed, and the incriminating character of the object must be immediately apparent. So sleeping dragons, apparent. Signs, you know, placards, even if they have a stick attached to them, probably not immediately apparent. And again, you know, just say, I don't consent, and let us fight that for you. So those are the magic words we want to make sure everyone memorizes. We do these trainings for immigrant communities, and we teach Spanish speakers to say these words in English just so that they can get out of ICE raids and things like that as well. Okay, contrast that to a subpoena. You know, sometimes people think these two words mean the same thing, but they actually don't. A subpoena can be issued by a government agency, but it could also come from a corporation. Or I can issue a subpoena as a lawyer. It's just a piece of paper that I can sign and send off to someone and demand things, documents, or other stuff. There are two different kinds of subpoenas. One, you know, these are Latin words. One is ad testacandum, which just means you have to show up and testify with words. You know, you're being subpoenaed to a grand jury. You're being subpoenaed to give a deposition where you have to show up and answer things out loud. And then a subpoena ducis tecum means you have to produce documents, records, tangible things. Now, if you refuse to comply with a subpoena, the person or entity that issued that subpoena is going to go to a judge and say, hey, I issued the subpoena and they won't comply with me. And the judge will say, you come do that or contempt of court. And contempt of court is a court proceeding, it's a civil court proceeding. If you are found in contempt of court, it can result in jail time. It can also result in fines, monetary penalties. So, you know, TransCanada subpoenas me for my diary, and I tell them to F themselves. They're going to go to the judge, they're going to get a motion to compel, and if I continue to refuse, I'm going to be found in contempt of court, and then the court can sanction me. Quick one?
Yeah. Can you be extradited to another state if it's a state subpoena?
Yeah. Yeah, but they have to pay your travel.
Oh, you have to pay your travel.
Grand juries are, you know, a form of government harassment and repression, particularly of political communities. A grand jury is basically this secret tribunal. If you receive a grand jury subpoena, you have to show up to a government courtroom and you walk into a room and there's a prosecutor, a court reporter, and the grand jurors. There's no judge. The prosecutor can ask you whatever they want. Sometimes even the grand jurors get to ask you questions. If you answer even a single question beyond your name, you have waived your right to not answer questions. Meaning once you start answering, you don't get to pick and choose which ones you want to answer. And you will have given up defenses that you might have to being forced to testify. We represent a lot of people who resist grand juries based on the political witch hunt nature of them. If you refuse a grand jury, you can be held in contempt of court as well, and you can end up in jail sometimes for the duration of that grand jury time period. If you get a grand jury subpoena, contact us right away. We'll help you find a lawyer, or we will, give you the full lowdown. There's actually a 1-hour training that we do just on grand juries.
One question.
Yeah.
Grand jury proceedings, they're private?
They are secret, yeah, meaning you can't get transcripts of them.
Have you ever been successful in getting transcripts from the grand jury?
No, but one important thing is the person who is the witness holds the key to that secret. So the witness is the only person that can actually divulge what went on in those rooms. And so in some places where we've, dealt with this, if a witness, is deciding to testify, they can come out of that courtroom, stand up in front of a microphone, and tell everyone every question they were asked and what their answers were. And they're the only one that holds that secret. It's very, very rare that there are other mechanisms to sort of get those secrets out of the grand jury room.
Witness dying. Witness dying.
Witness
When
dying.
the witness dies, it unseals.
Oh, yeah, right, yeah. Yeah, if a grand jury witness dies, if they pass away, then that secret is no longer a secret, and you can often request transcripts at that time and pay for them. Okay. So now it's your turn. Yeah.
Sorry, folks. Yeah, okay. A lot of what Lauren said, many people will imagine the stuff happening sort of in the real world, but a lot of this stuff also happens online, and so I wanted to bring your attention to the threats that we've seen being used against activists currently. So there's a lot of threats that are possible, or a lot of threats that we know about from, say, for example, the Snowden disclosures of 2013, but we haven't necessarily seen those threats play out in our activist world. So we're going to focus on the threats that we have seen taking play and what you should be aware of with those threats. But first, just a quick idea of what surveillance is and how people think about surveillance. This is the classic way to think about surveillance. This is the panopticon. It's designed for a prison where all of the cells are around the outside of a circular prison with the door of the cells facing inward with a single watchtower in the center. And the idea is that the lighting in the watchtower is such that you can't tell if there's a guard present inside the watchtower. But the idea that you could be watched, surveilled at any point in time by that guard forces the prisoner to conform to the ideal prisoner, someone sitting quietly and not doing anything. And this has been used as a metaphor for state surveillance since the 70s. Foucault who said that we live in a panopticon with what we would normally think of this picture with an all-seeing eye. One would normally think of this as being the government who sees everything that you do. And in the 70s, it wasn't necessarily that you were being surveilled all the time, but you could be surveilled at any given time, and that would make you conform and not take part in dissent and activism. But in reality, the world that we live in, we don't have a single all-seeing eye that has the ability to see you at any given point in time. What we have are tons of eyes that do see everything that you do all the time, but who's seeing what depends on the context. And I know this image is a little bit confusing. You might hope that, oh, well, all of these corporations are in the prison cells, yay. But the idea is that we're turning this around, and really the prison cell is in the middle, right? And you are in the prison cell, and you're being watched by all of these different entities, okay? Including government agencies like the NSA and the FBI, but also corporations like Facebook and Apple and Google, AT&T. All of these companies that we rely on in the modern day world for our communications. So I'm going to cover a few different aspects of surveillance that is being used. The first is social media. So many law enforcement agencies across the country use special software that is marketed to them to surveil their given population. Special software to surveil the social media that people are using in their jurisdiction. The Warrant Center for Justice uncovered that at least 127 government agencies across the U.S., and we expect this to be a significant underestimate, are subscribing and using social media monitoring software. There's been a number of stories about the use of social media monitoring software in the past several years. Geopedia was notorious for marketing their product to law enforcement specifically to keep track of Black Lives Matter protests. It was subsequently, Geopedia was used by Oakland and Baltimore law enforcement to identify Black Lives Matter protests through their social media feeds. And they matched those feeds to face recognition software that they had on handheld devices that they went out into the protests to use. And if they had a match between someone's social media feed and a picture of someone in the crowd with an outstanding warrant for that person, often for something as ridiculous as unpaid parking tickets, they would take that person off the street. The Oregon Department of Justice used a trial run of digital stakeout for a month, and within that first month, one of the users of this social media monitoring software monitored the hashtag Black Lives Matter and drew attention in a very negative light to one of the Department of Justice's own attorney, and sent a memo around through the Department of Justice saying how terrible this was and we should do something about this attorney. It was the Department of Justice's only black attorney, and of course sued the hell out of them after that. SnapTrends incorporated the use of undercover accounts. So this is infiltrators online. For Facebook to be useful in social media monitoring, it used to be that Facebook gave access to all of your account information even if you had it set to private. So usually social media monitoring software only relies on any public information that you have. So anything that any citizen could look at online, even if they're not your friend or following you. Facebook used to allow companies that were designing social media monitoring software to go behind that screen. When that was discovered, they stopped that practice. And so to recover the vast amount of information that was behind that screen, SnapTrends incorporated undercover accounts that would automatically make friend requests that seemed legitimate to these super nodes in Facebook, these people who have many, many hundreds of friends and basically accept any friend requests that they're given for the sort of cachet of having yet another friend. But these undercover accounts were really SnapTrends accounts that allowed law enforcement to go behind that privacy screen and see everything in their account. Most recently in the DAPL camps, Tiger Swan, which is this corporation that was hired by Energy Transfer Partners to monitor the situation using techniques that they perfected in the Middle East. Tiger Swan's internal situation reports were leaked to The Intercept, and reading them, almost every one of their internal situation reports has many, many links to specific Facebook posts by activists, and always include these plans to monitor social media moving forward, saying, in the next 24 hours, we will continue to monitor social media. They also engaged in the practice of creating fake accounts and fake stories to sort of discredit activists, which shows that there was an opposition to the activist camps when there wasn't.
DAPL.
Dakota Access Pipeline.
And, from my experiences out at Standing Rock, we actually watched police, we would have car convoys that would get stopped, and police would have this camera thing that almost looked like the size of this projector, and they'd walk down the cars right at the window level and shine this thing into everybody's cars, and then occasionally they'd stop and start pulling brown people out of the vehicles and arresting them. And what they were doing is using Facebook, other people posting pictures or videos of things that were technically illegal, like spray painting equipment or minor things, and then they would use the facial recognition software to match the Facebook post with the person in the car, and they were pulling them out and arresting them for that.
Lauren described what warrants are. Warrants are these legal requests for information that require probable cause. The way most people think of warrants is someone showing up to you and showing you a paper copy of a warrant, but warrants online for your online information aren't delivered to you, they're delivered to the company that hosts your data. And this is done through, as I understand it, the third-party doctrine. Do you want to say something about that?
Well, basically, this is the situation where, the FBI is investigating you for something, and they want to look at your text message logs or your emails or, even what you store on the cloud. And so they send the warrant to AT&T or to Google or whatnot and compel these corporations to give the state all of the information that they're requesting, and you are not notified and you are not aware that it's going on.
Many companies have these wonderful things called transparency reports, where they care about their customers and they want their customers to know everything that they're doing to respect their privacy, including how much of their information they're handing over to law enforcement and other parties when they're asked nicely for it. Some places like the Electronic Frontier Foundation will give points to companies for having a transparency report, even if their transparency report shows that they hand over account information and content from tens of thousands of customers every year. So the next, I'm going to show you transparency report data from Facebook, Google, and AT&T. And so these are, the yellow are data requests to Facebook by way of a search warrant, so that requires probable cause. And the red at the bottom are data requests to Facebook by a subpoena, which does not require probable cause. That's
something I can issue, or a corporation can issue in addition to the state.
And Facebook says, we do fight some of these data requests. Like some of the data requests are for accounts that don't exist. But what they do say is that they return data in roughly 80% of requests, and each request impacts on average about 1.5 user accounts, which comes out to over 100,000 accounts being affected every year.
Pen registers and wiretaps also require probable cause. Those are kind of a form of a search warrant in effect. Emergency disclosures mean that they're saying they don't need a search warrant because it's one of those exceptions to the search warrant. Other court order, obviously there's at least some court oversight. But preservation requests, that big black one that you see there, that's not necessarily like, give me this stuff. That's telling Facebook or whoever, don't destroy it. You have to take all that data, put it in a safe, basically, and hold on to it because we might want it in the future. If you were following the ETP, Energy Transfer Partners, slap suit that we talked about yesterday against Greenpeace and several other organizations, one of the things that ETP did is send out a ton of preservation requests saying, save all your text messages, calendars, emails, documents, etc., photos, blah, 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 because we might subpoena you for them or, require you to produce them in the future. Partially, this was to scare people, to chill them, because chances are ETP is not going to get 400 people, got us, hundreds of calls into the office, like, am I being sued? Or what should I have done before I got this in order to make sure that I don't have a bunch of bad stuff that I'm now gonna be forced to turn over, which is why we decided to do this panel today.
And this story that I list at the bottom from the Intercept was really interesting. It was a story about anti-pipeline activists in Washington State, and a county prosecutor making attempts to ask for Facebook records of the anti-pipeline activists, and the prosecutor, being kind of maybe a little bit naive, never having done this before, had back and forth with Facebook, where Facebook helped them draft the appropriate wording for I think in this case it was for a subpoena to request information. So these companies they're not. Okay, so that's the thing to remember, right? That they're going to help law enforcement whenever they have to. So this is request for Google data, and you'll notice this like very stark upward trend in requests, probably from understanding the wealth of information that's available in Google. Again, Google returns data for roughly 80% of requests, and each request impacts on average roughly 2 user accounts. The important thing to understand about what can be requested, so with the subpoena, most often only non-content data, metadata, like to and from, and who's contacting who and when can be requested. But for email, and most likely cloud storage, which is often considered in the same vein as email, it is treated in a way that was determined by the law in the mid-'80s when people were first emailing, and when people were first emailing, they were using email much more in the way that they use the postal mail, where an email is sent through the internet, and that doesn't stay on external servers. Once it gets delivered to your computer, that's it, it doesn't exist anywhere else. But the way we use email now is we log into our Google or Yahoo accounts, and we check our email, and our email stays on those Google and Yahoo accounts. And the way the law treats this is it says, well, you've read your email, and you've read your letter, and you left it on the account, on your account. You've left it on the Google or Yahoo servers. And so now it's discarded as though it's a piece of garbage that has been discarded on the street, and it's perfectly legal for the government to request the content of that garbage, just to pick it out of the trash and read it. So email, the content of email can be accessed with a simple subpoena. And so this is, not something that's protected at all.
Right, which means, TransCanada or Enbridge or me can send off a subpoena to Google and literally get your emails. And, if you're using the Google Suite, which a lot of the largest environmental groups in the country are using right now, then, everything that is stored on the Google Suite could be accessed by a mere subpoena. No probable cause required.
So if you have deleted the emails, are they gone?
Probably not. It depends. I mean, you can go and look at the particular end user agreement that you have clicked through when you got your account, and which changes every 6 months or so with various companies. Google is notorious for never deleting your emails because they use those emails to make money on you. They use those emails to figure out how to best serve you with ads so that they can derive income from you. So this is something that you need an ounce of prevention, right? Dealing with it after the fact isn't the right way to deal with it. And most likely these rules hold for sort of Facebook messages, which would probably be considered similar to mail, similar to email by a court of law, and the same with cloud storage, so Google documents and Dropbox documents.
And we, CLDC has a digital security for activists program. We do trainings on how to encrypt your emails. Encrypting your emails is really the only guaranteed way to ensure that when I do subpoena your emails, I'm just going to get a bunch of gibberish that I can't read. If you're not doing that, your communications are vulnerable.
The advice that CLDC gives to say, whenever you're presented with a search warrant, or whenever a agent of the state approaches you and starts to search you, to say, I do not consent to the search. There's no way to do that with your information that's not in your hands, right? That's on some remote server. The only way to do that in an electronic way is to have that stuff encrypted.
people ask us all the time, oh, isn't encryption gonna like draw attention to us and make us look sketchy? But literally, you know what Cora just said is true. Like, if the cop wants to search my pockets, I say I don't consent. And the way we say I don't consent with regard to electronic communications is encryption. It does not draw attention to you. It doesn't mean that you're sketchy or they're gonna target you more. It literally, is an assertion of your Fourth Amendment rights.
So this final graph, which I'll go through quickly, which is just basically to show that data request to AT&T is on a different scale from Google and Facebook. Is roughly a factor of 10 more data requests every 6 months. Many more subpoenas. A lot of those are criminal, but there are a lot of civil subpoenas. And the trend is kind of steady or maybe possibly decreasing. I think what you'll see over time is that those data requests will be increasingly going to online companies rather than phone providers.
Can you go back one more second? So the ones that are saying real-time data, just to be clear, like when you see that dark stuff, what that means is like every time you're using your phone, there is somebody listening to you on the phone, which is pretty shocking to see how many of them are actually in existence. Because you hear about that stuff and you're like, oh, that won't happen to me. That happens to spies in Russia or something like that. But in fact, there are humans sitting in an office space in various places, literally listening to people's phone calls.
These are just cell phones?
Well, anything through AT&T, so.
It's like 15,000 of those wiretaps is still coming.
15,000, yeah.
Okay, yeah. Right, so.
What do you recommend in lieu of the Google Suite?
Well, we are using Nextcloud, which is a May 1st thing. They have emails, they can host your documents, your website, and they have basically the equivalent of Dropbox, collaborative document stuff. So I would suggest, depending on the size of your organization, checking in with them. NEXTCLOUD. Yeah, it's a group May 1st. We actually interrogated the snot out of them before CLDC switched to them, and they have a warrant canary, and they also have committed to going to jail for grand jury resistance if they are compelled to produce records and information from you. A warrant canary just means if they are served a warrant or a national security letter, they're going to alert people that they have been compromised so that you pull your stuff off of them, basically. Okay, so I wanted to show you this slide. This is a quote from a FOIA document that we received showing how cops are using Facebook information. So a police officer in Richland, Benton County alerted investigators that he believed this particular person was going to commit a crime based on advanced Facebook surveillance. So May Day happens every day on May Day, or every year on May Day. They know it's coming. And so months beforehand, they start trolling Facebook, looking for who's the mover and shaker, who's organizing what, blah, blah, blah. In this case, this poor chap literally posted about building Molotov cocktails and saying things like, it's gonna be a blast. The complaint that was eventually filed in federal court against him to obtain warrants and other things, they got his DNA, they got his fingerprints, they met him as he got off a plane, and basically this guy lit off a couple of Molotov cocktails, they went a little awry, he throws down his diaper bag full of Molotov cocktails and runs. Of course, the cocktails have his fingerprints all over them and all sorts of other things in the bag that linked them to him. He then, when he was met by, so he builds Molotov cocktails, he uses them, and then when the cops come up to him, he just sings like a canary, basically, and starts admitting all of the things he's done and why he's done them. You know, he's influenced by the anarchists in Greece, like, you know, he obviously never went to our security culture training or Know Your Rights training. He claims he panicked and dropped the diaper bag and made a run for it, and, you know, was facing 10 years in prison. You know, so I show this for not only to show how they're using Facebook, but, you know, if you're building Molotov cocktails, you might want to know your rights, and you might want to know that you shouldn't be talking to the cops after you get caught doing it. Okay, now back to you. Oh, okay.
So final couple of slides on, second here. On cell phones. So cell phones are dangerous little devices. They have a lot of information on them. They're really easy to lose, right? Even if you don't lose them, there are these things called IMSI Catchers, or more popularly known as stingrays, which are essentially imitation cell phone towers that can be purchased from, you know, a budget, you know, between $20,000 and $134,000. And they can do various things. Different ones have different capabilities, but they can easily block or intercept cell phone traffic. So what they do is it creates a little mini cell phone tower in your region, and because the signal is stronger than the actual cell phone tower, all the phones connect to this little imitation cell phone tower instead of the real cell phone tower, and so all the traffic goes through this imitation one, and they can just continue to route the calls on to the normal network, so you can't even tell if your cell phone is being traffic is being intercepted by this stingray. They can block traffic. You can just collect the phone numbers of everyone who's in the area. More fancier ones can collect the content and metadata of all of the calls. If they're not encrypted, they would collect the content. There is generally encryption with the modern cell phone standards. There's generally your data is encrypted between the phone and the cell phone tower, like the actual cell phone tower. But these IMSI catchers can downgrade that encryption level, make it seem like it's using an older standard, which can be broken on the fly by these little portable devices. 72 government agencies are known to have them in 48 states. Corporations can buy these things. They were initially used by countries spying on one another, apparently, like back in the day, probably still. If you go, you know, down Embassy Road, Washington D.C., there's just like highlights of tons of these cell phone tower or imitation cell phone towers that you could tell because they appear and disappear over time, or they might move like a real cell phone tower. But with proper use, it's very hard to detect the existence of these cell towers, these imitation cell towers. And the middle one is interesting just to show that, you know, that's a real size coffee mug. They're very small devices, right? These can be, you know, in a van, in a car. They could be in a backpack. Cellbrite is a company that helps get data off devices. They're so helpful. They create these little computers that you just plug in a cell phone, like an Android or an iPhone, into it, and it sucks all of the data off those cell phones. And so these are things that can be if they're small again, right? This is the size of this device. It can be used inside the cop car. So if your cell phone is taken off you when you're arrested, the data can be pulled off it. And it seems like even if they don't have the legal right to look at that data, they can keep that data until they do have the legal right further down the line. So it's always best practice to encrypt your data on your phone. So iPhones do this by default. Use a strong password. Androids, you have to turn it on. I think is still current. You have to opt to turn it on. Again, use a strong password. If you don't use a strong password, they could easily break the encryption that's protecting it, given a little bit of time. But if they've already stripped all the data off the phone, they have access to that data.
And note that even deleted data can be extracted from this device.
Yeah, so when the data from, you know, if you delete photos from your phone, it doesn't actually delete the data, it just deletes access to that data, and so that data doesn't disappear until you overwrite that photo with another photo sometime later. Celebrate also creates programs to extract information from cloud-based service, cloud content providers. That's not a very complicated. Yeah.
Okay. So now I wanted to give a few more sort of specific case examples
Can I ask a
of,
quick cell phone question? So we meet with groups and sometimes they say we should put our cell phones in the back room because someone could listen to us. Is that a legitimate concern?
it's called hot miking.
We haven't heard of
What's
that
the
happening
question?
The question is, sometimes in meetings, people will say, let's all take our phones and go put them in the refrigerator or go put them in a different room so that we're not being spied on, and is that legitimate or not?
We haven't heard of this happening to activists. It is a capability that exists. It is possible to do this. This has happened in targeting organized crime. I would say it's good practice to get used to organizing those devices around. And if it certainly makes one person more comfortable in the room, then it's worth it as well.
Okay, so corporate surveillance is also called gray intelligence, and wanted to kind of, sometimes people are like, oh, is this stuff really real, or is this something Lauren makes up in her bad dreams at night? And this is actually a document that we got through FOIA. Themis is a private spy agency, a corporate spy agency, and this document, which was back in 2010, is a very classic example of what we see from corporate spy agencies. This group was hired by a group to spy on U.S. Chamber Watch. This is literally an above-ground, totally legal organization that monitors the U.S. Chamber of Commerce. Woo, really rad. But in this document, they come up with their plan of how they're going to infiltrate and mess with this watchdog organization. It includes, paint U.S. Chamber Watch as an operative of the Communist Party so that everybody hates them. Craft a message to combat their propaganda. For example, target how the unions are being an inhibitor to progress by advocating for unrealistic individual benefits. Create a false document. Tell the group that we have this whistleblowing secret document. And then when they take the document and go to the media and say, look what we have, then this group will come forward and say, those liars, they're lying to you. This is the real document, and basically totally discredit you, in terms of fake whistleblower in essence. Connect the U.S. Chamber Watch to radical tactics of the Velvet Revolution, trying to smear them into something that they're not. Number 5 is one of my favorites. If needed, create 2 fake insider personas, using one as leverage to discredit the other while confirming the legitimacy of the second. Such work is complicated, but a well-thought-out approach will give way to a variety of strategies that can sufficiently aid the formation of vetting questions U.S. Chamber Watch will likely ask. And then number 6, create a humor piece about the leaders of the organization.
So who hired them?
Yeah.
In this case, it was the U.S. Chamber of Commerce hiring them. Yeah.
Just wanted to confirm that.
Yeah. Now this, you can't really see it because I'm sitting here, but if you look in the corner here, you'll see TransCanada's logo. This was a PowerPoint presentation that TransCanada gave to every FBI office and local law enforcement agency all along the Keystone Pipeline route. So long before we even knew that there was a plan in the works for this, TransCanada was giving PowerPoint presentations telling the cops and telling the FBI, hey, we're gonna put this pipeline in and we think protesters are gonna come and this is what we want you to, this is what you need to look at, does Oklahoma Penal Code have a similar law to the one we really love in Texas? And here we go is a nice schematic of what a sleeping dragon is so that they can quickly cut people out of them. It also included who they viewed as the leaders, pictures of them, their names, their background, et cetera, and they encouraged these local prosecutors to go for the gusto and, you know, use federal anti-terrorism laws for these people who are standing on the side of the road holding signs, you know, basically. And now, you know, just to say it, you know, don't overestimate these guys because they thought this PowerPoint was going to be a top secret thing. But because they gave this training to the FBI, we got it through FOIA. Because once they give it to the government, we can get it through FOIA. Unfortunately, it takes a while for us, you know, as anyone who's ever done FOIA, it, you know, years later you get, you know, the goods sometimes. So, okay, and now I wanted to talk a little bit about Tiger Swan before we open it up for questions. At ETP, James Reese and John Porter are basically the founders and head honchos of Tiger Swan, who were one of the private spy agencies that were out at Standing Rock. They are both ex-military head honchos, like high-level operatives. John Porter previously served as the 1st Troop Sergeant Major in A Squadron, which is one of the Special Forces Operations Detachment Delta units, commonly known as Delta Force, or one of many other code names. They are the premier counterterrorism strike force. They are on constant alert to respond to military emergencies worldwide. And so when Tiger Swan first got hired for the DAPL contract, for the Dakota Access Pipeline contract, the first thing they did was try to squeeze out all of the other private contractor security agencies that were there so that they could bring in all their former Army Rangers and military intelligence people to fill the ranks of their company. Almost all were veterans of the military, and Porter was mainly interested in perpetuating the protest, you know, to keep it going and to provoke protesters into becoming more violent. He didn't care about whether anything was legal or not, and of course one of the primary motivations he had was to get paid for as long as possible. So, you know, we saw, you know, not only did he want it to go on for as long as possible, but by constantly saying like, oh, they're terrorists, oh, they have guns, oh, they have this and that, that ensured he was going to get a paycheck for longer. Now, they also tried to hire a bunch of active military people. You know, literally military people were taking leaves from duty to come work for them to like double and triple their paychecks. Now, that's actually illegal pursuant to an executive order which bars U.S. soldiers from moonlighting as like posse comitatus style, you know, private security people. One of the big selling points that Tiger Swan used to sell their services to ETP for the DAPL contract was that the company used what they billed as a proprietary app for their smartphones called Guardian Angels, which could be used to track their employers who were prolifically infiltrating the Standing Rock camps. This app called Guardian Angel is also used by celebrities. You know, so if Justin Bieber gets surrounded by fans and freaks out, he uses this app and his security people come to his body right away and can escape him and get him away from, you know, his fans. And so Tiger Swan was using this app all the time while they were out at Standing Rock. This is from a great article that I'm going to give you the link to in a minute. A friend of mine who actually is ex-military is on this military listserv, ex-military listserv, and this article was sent through that listserv. I had never seen it anywhere else, and I'm going to give you the link to it because, boy, was it an eyeball full of really interesting information. This is a quote from it. A Tiger Swan employee commented on what was being discussed at the company's headquarters in North Carolina, that the head honcho, John Porter, was throwing people undercover in with the protesters, and it wasn't just for intelligence gathering, it was more or less to incite them to do other things that would make Tiger Swan a relevant necessity to continue to be paid money for security. Yeah. Porter, this has to do with like them going into camp and being provocateurs. Porter was known to drive his pickup truck to a position over watching the North Bridge that crossed the Cannonball River. How many of you were at Standing Rock? You remember the bridge, and maybe you've heard of, what ensued on the bridge afterward. The body of water that separated the protesters from the ETP oil pipeline construction site. From here, he would get on the radio and mimic the calls made by the protesters themselves in the early days of the protest before they got wise to the fact that the contractors were monitoring them. He would yell, "All warriors to the bridge." Porter would order over the radio, pretending to be a protester, "Everyone to the bridge, all warriors to the bridge." And if people didn't come, they would say things like, "Where's Red Warrior?" Blah, blah, just basically chide them and provoke them. And as many of you know, there ended up being this major standoff at the bridge. We represent Sophia Walensky, who had her arm almost blown off that night. One woman was blinded by a rubber bullet. A number of people had their scalps ripped off by rubber bullets. People were gassed and, shot with water cannons on that frigid night. And we're still in the discovery process, and I know this is on the radio, but I have a little theory going on about, why that played out the way it did. And I think this is some, fairly good evidence of, maybe what was going on there. So 2 really good articles. One, The Intercept, they did a whole series called Oil and Water, in which they got a bunch of leaked documents as well as other documents, really instructive. And then that other one that I'm talking about that was from that military listserv, is down at the bottom. I'll put this back up at the end and people can take pictures with their phones or jot it down at that point if they would like. Now this, yeah. We have not filed Sophia's 1983 action yet, but we intend to include Tiger Swan as a party. And if you went to my talk the other day, when a private corporation acts like a government agency, when a private corporation acts like the FBI or acts like cops, they stand in the shoes of those cops and can also be liable under our civil rights laws, just like the cops would be. So, not to, blow our cover, but yes, we do intend to join them in that lawsuit. This is an internal Tiger Swan email written by one of the contractors who began trolling Facebook and other social message apps looking for vulnerable protesters, mostly Native American men, and started blackmailing them in order to turn them into informants and infiltrators. And so this, basically says I'm starting an initiative. I want people to inform for us for pay. Go troll these places. Look for people with family members in the hospital, with criminal charges pending, people who are on probation, parole, drug addicts, et cetera, and start trying to find good candidates. And he says we win no matter what. If they tell our pitchman to go fuck himself, the activists will start wondering who did take the money, and it'll cause conflict within the activist groups, and it won't cost us anything. I haven't determined who we'll use as our pitchman yet. That will depend a lot on where the activist is located. So clearly, they're fomenting, suspicion, divides, unease within the Standing Rock community, which certainly was successful. Many of you might have heard of Red Fawn Phallus, who was arrested and was accused of shooting a gun at one of the eviction protests. It turns out the gun was owned by her boyfriend, who turned out to be a paid FBI informant. She was facing life in prison for felon in possession of a firearm and other things. She has recently taken a plea deal, and that infiltrator, started infiltrating camp back in August, and that was, basically one of the major costs of that kind of spying. And that is, there is a ton more that is coming out every day, especially at Standing Rock. It's going to kind of become my new, sort of test protocol for all things bad with regard to corporate intelligence and activism. It really makes it important to sort of go back to those basics of, trusting, small groups of people, using, security culture protocols to a higher degree. And, if somebody seems like a jackass, whether they are a corporate spy, an FBI agent, or just a dysfunctional jackass, you probably shouldn't be working with them. You probably shouldn't be breaking the law with them.
Can you put the links back on?
Yeah, I will at the end.
Just wanted to get this up, so the CLBC does offer digital security trainings to activist groups and nonprofits, and that can take a number of forms. So I'll leave this up for a little bit while we take some questions, and we'll switch it back over to Lawrence.
Yeah.
Can you go back and get into a little bit about the threshold for private companies, like pipeline companies, to use a subpoena to get third-party data, like if you're hosting on the cloud, stuff that, completely above board, legal activities, administrative type stuff. There's got to be some thresholds there, because obviously, I can't just write a subpoena to Kinder Morgan and get, whatever documents they have. So what, where are the lines there?
Sure. So normally, what we used to sort of assume is, in order for me to issue a subpoena, I have to have an ongoing case. I have to be able to put a case number in the box. And then I file it with the court puts a stamp on it, and then I send it out. So there was at least some protocols. But what we are digging up from some of the research that Cora is working on is that a lot of times these corporations are using old or ongoing cases for instance, like if they're suing somebody for intellectual property, somebody who is maybe like stealing some part of their software that they developed. They'll use that as the basis of the subpoena, and then do this broad subpoena for all sorts of documents and records that they are, claiming is for that purpose, but actually it's for another purpose. Because you don't know about it, you don't get to challenge it. The only way we're finding out of these things is once somebody is busted, it has to be disclosed in the discovery. And if they did share it with the government, then we can potentially get them through public records or FOIA. So there used to be a pretty clear black and white standard for getting a subpoena and issuing a subpoena. That seems to be changing, and because the law is having a real hard time keeping up with advances in technology, there are some really large gaps right now, especially with regard to the cloud. There's been a few bills that are currently kind of being bandied about. One is called the Cloud Act, that was supposed to start putting mechanisms in place to protect your cloud stuff, but a bunch of right-wingers have gotten a hold of it, and it's actually now just basically legalizing spying on your cloud documents. And it has basically gutted the protection part of it and just sort of like green-lighted the illegal activities that the government is currently doing, taking advantage of this sort of gray area that's currently existing. Yeah.
Could you speak to the legislation that's now moving through state courts, has been for the last 2 years, being introduced to criminalize protests and freedom of association, and that's being promoted by Energy Transfer Partners and ALEC? You're familiar with that?
Sure. That has been going on for as long as I've been a lawyer. That's 20 years, especially with regard to ALEC. my position on it is, yeah, we should definitely be monitoring all of these bills, and there are organizations that should be commenting and speaking about them, et cetera, but the overwhelming majority of these bills never get passed. There's a very few handfuls that actually become law. Once they become law, we love challenging the constitutionality of these jokes. And most of them end up being found unconstitutional in the courts. So yeah, it's there. It's a little intimidating and scary, but don't over-respond to that because A, chances are it's not going to become law. B, if it does, even if you get charged with it, call us. We'd love to defend you and fight it. And more often than not, we are winning in those challenges.
And there is a website called U.S. Protest Law Tracker.
Yeah, several groups are doing really good work in trying to track them.
And basically, exactly what you said, 58 bills have been introduced and 8 have been enacted. 28 are pending.
Yeah.
Are you talking about federal or state?
State, in 50 states.
So with subpoenas, how does that work with like end-to-end encrypted messaging services like RiseUp or Signal, and those often have like disappearing messages and stuff? With a subpoena, is something like that accessible? Like once something is deleted from an end-to-end encryption messaging service, is that still somehow accessible to government and corporations?
Right, so if you are, so this is one reason why we love to push people toward end-to-end encryption, like using email encryption or using an app like Signal or Wired, is there, you have the encryption key, you and whoever you're communicating with are the only two people who have the encryption key, right? So anybody who accesses that information in the middle, be that, you know, a eavesdropper or a government or corporate request to some server that's along the way, they would only see the encrypted version of it and they wouldn't have the key. The only way they would get the key is to get physical access to your device or by like hacking your device using some kind of malware, right? But really it's forcing the effort to do surveillance of those messages onto your device as opposed to all of these servers in the middle, which are much easier for them to access.
Also, don't forget prevention. You know, think about, do you really have to say it's gonna be a blast in writing or send it to someone, you know? It actually kind of plays off of that. So in that real-time data that they are collecting, potentially, I mean, there's, you know, it's a very small amount. If you're on Signal, is that encrypted then, or can they still access that?
So that would be encrypted because those kind of those kind of real-time requests are being made to AT&T itself. They would have to reach into your phone, which they would have to do via other mechanisms, which we haven't seen in play.
But what has happened is somebody drops their phone without a password on it, and the cop can just literally go look through all of your Signal texts because they're not disappearing, and there they are in the phone. So, you know, you absolutely need a password on it. You should do preventative deletions and not keep the world on your phone forever. You know, thanks to Cora, I no longer have my email on my phone. You know, you really want to think about what you've got on your phone and how much is on your phone in the event something bad happens. And the other thing is, you know, a lot of people use like the thumbprint passwords because it's easy while you're driving, but there have been instances where law enforcement has forced someone's thumb onto their thumbprint and accessed their phone in that way. Yes, Mr. McGowan.
I don't want to belabor the point, but so if a law enforcement repeated Signal, for instance, forgetting about whether Signal would comply or not, if they did comply, what they would get is a bunch of gibberish, right?
Yeah, so if Signal did comply, the most they would be able to get is who's communicating with whom and when.
And we're pretty clear that they're not complying.
Yeah.
They've been tested.
And there have, I think, been requests that have been denied because they don't keep the information. So there has been some evidence that they're not keeping that information.
Does CLDC offer more specialized help, such as I'm encountering what I consider to be abuse of the main name registration process from each silver bullet? I would recommend staying away from them. They
We don't
Yeah.
do that level of detail, but maybe EFF might. You might want
EFF.
to contact the Electronic Frontier
Okay.
Foundation.
Question, I recently found out that like at airports, when you're going through customs stuff, they can just like decide to pull you out and check your phone and everything, and it seems to be like you don't have a choice in it. Like they're just gonna keep you there if you don't consent. And wanted to know if you know anything about that, and like what steps you can take to prevent like having everything, all your messages read, and going through those kind of checkpoints.
Yeah, we do a special training for boarders, especially for our friends that are doing work in Canada back and forth. And really the best practice is to not bring your phone or computer with you at all. Bring a burner, bring, a thumb drive, bring a Tails, drive or something like that. And don't even bring either device. If you are going to, you might want to have like an iPad or something that you use when you travel, and just don't ever put stuff on it, because deleting it may not be the same as like it never having been there.
Yeah, 'cause I mean, like, it's like Facebook message, anything like that, they could like just go onto the website, even like through your phone, like, so if you just like delete everything, delete all the passwords and the apps and everything, it's like a pretty safe pass through that way.
Yeah, I mean.
Safer.
Yeah.
Safer, like as we've seen with that Celebrate device where they just plug in the phone and strip data off it.
That's what I was thinking.
That kind of data, even though you deleted it, may still exist in there.
And I mean, I can't tell you in the last year how many times we've been called from activists who had their phones seized or computers seized at the border or, at a TSA location, and they literally watched the government download their device into a computer with all their address books, all their whatevers now fully compromised. And those people are not reaching out to you to say, hey, I just had my device compromised and you were in my address book, sorry, so.
So what should people do that say, for example, you had that comrade that went in there and got their device seized, and you were on there and you know that they now have that connection? Should we also get a new phone, or what should we go from there?
I mean, if a friend's device was compromised, then any information that friend had would be compromised, but not necessarily your account itself.
So it's just that connection, it's just
That
whether or not
connection
they-
or any conversations that you had with that friend that might live on the device itself.
Did you say the signal key that they had was compromised?
Yeah, so Signal is tied to your cell phone. If your cell phone is your cell phone number, so if your device is compromised or lost, the first thing I would recommend doing is getting in touch with the phone company and getting the new SIM card so that the old SIM card is no longer valid, and reestablishing your Signal contacts on that new SIM card. Wire is another end-to-end encryption app which has some added benefits that it's not tied to your cell phone. You create an identity for yourself with Wire, and it also allows you to have that identity tied to different devices, like your laptop and your cell phone. And if one device is compromised, you can pull the key corresponding to that device from one of your other devices that you have registered with it. So like if your cell phone gets lost, I could log in on my laptop and say expire the key corresponding to the cell phone, and then none of the messages would be readable on that cell phone anymore. So it's got some nice added features. Signal is much more plug and play, right? For anybody who's used it, you download it, you start using it. It's pretty simple.
Attached documents, et cetera, et cetera. But we are transitioning to Wire because it's not connected to your cell phone number. And also you can have encrypted conference calls with up to 100 people.
10.
Oh, 10.
I wish it was
It's almost 100.
Or via conference.
Wow.
Okay, well, I think we're out of time, so thank you.